The third case this morning is C-240158, State of Ohio versus Christopher Wright. Would you like to reserve time for rebuttal?
Please, Your Honor, 2 minutes. Thank you.
You may begin when you're ready.
May it please the Court, Nathaniel Truitt on behalf of Defendant Appellant Christopher Wright. The trial court erred here in convicting Mr. Wright of an OVI because it did so, to borrow from this court's words in State v. Anderson, it did so without any evidence of there being a confluence of impairment and the operation of a vehicle. The OVI statute has an essential requirement. Impairment must coincide or be concurrent with operation. And this court in Anderson articulated a fairly bright line rule that I think puts teeth to that statutory requirement. On the negative side of the ledger, this court said, suppose a person is found unconscious on the side of the road. He's impaired. A jury may convict that person of an OVI because there's a reasonable inference that the person had to drive to that location and thus did so while impaired. You have concurrence of impairment and operation. Then this court in Anderson said, but on the positive side of the ledger, suppose a person goes to a bar, becomes impaired, then decides to sleep it off in their vehicle in the parking lot. That person cannot be convicted of an OVI absent subsequent movement because you don't have operation while impaired. The only thing that person can be convicted of is physical control while impaired, and that's a separate charge that isn't an issue here. And so I think applying that bright line rule to this case makes this for a fairly straightforward reversal.
Counsel, is the type of movement that we're talking about, so I understand the statutory definition of operation is causing movement. Is the movement that we're talking about the movement of a car forward by its tires, like actually moving down the road? Or can the movement of the engine when a car is in park, does that constitute movement? I mean, something in the car is moving when a car is in park and the engine is turned on.
I haven't seen any case that would suggest that movement of the engine or any other part of the vehicle could constitute operation. Every case that I could recall, the concept of moving or of operation or of movement entails the vehicle itself, the tires, presumably, moving usually along a roadway, but I suppose it could be an open question as to location. But does that answer your question?
It does.
I think the issue of movement historically went to whether, maybe if I could zoom out maybe slightly further. Historically, as I understand it, the judicial interpretation of operation went to additional things besides actual movement of a vehicle or movement of the tires, and entailed things such as physical control of the vehicle, whether you had keys in the ignition. But since 2004, when the legislator amended the statute, added the physical control violation as a separate charge, then it seems that the statutory language is much narrower when it pertains to an OVI, that the movement must be physical movement of the tires. I think would be the simplest way to ascertain or put a standard to that.
So in this case, the vehicle was in drive, which then I think opens up the argument that that can be evidence of movement. Can you address that?
Sure. It certainly opens up the argument, but at trial, the state just simply did not show anything to suggest that the car actually moved. In fact, the state's only witness, the police officer, confirmed that he sensed or felt no movement of the vehicle. And of course, Mr. Wright showed video evidence demonstrating how the vehicle's emergency parking brake system would have prevented, and in fact did prevent, any physical movement of the tires or of the vehicle. And he additionally testified to the same. And so while it's I would agree with Your Honor that it raises the argument. The state just did not put anything forth in the form of evidence to suggest that movement actually occurred.
So there's also case law out there where, given the circumstances of how the vehicle was found and where the accused is found and so on, that the trial court seems to make an inference of movement despite no direct evidence of movement. Do you understand what I'm saying? Okay. So how is it that that would not apply here?
I think there's two things. The first is that all the evidence of impairment here suggests that the impairment.
Let me just quantify that a little bit. Let me just clarify that, because it's, it's while impaired, right? So it's sort of like trying to figure out whether there was movement after the impairment or not, okay? So that's really, we're putting the question all together.
I think there's perhaps two things. I apologize, I don't remember which case, but one of the cases made reference to the idea of a vehicle being parked halfway on the parking lot and halfway on the street in an odd position.
Mm-hmm.
And of course, there are a lot of other cases that this court cited in Anderson that show a vehicle being in sometimes odd locations or on the side of the road. I think the key distinction with, I believe, all of those cases is that the impairment was clearly simultaneous with either the movement or the odd location of the driver or presumed driver or the vehicle. I think the other issue here is that all the evidence in this case of impairment suggests only that the impairment occurred at the gas station. And Anderson, I think, highlights this point. In Anderson, the defendant was found unconscious in a parking lot. The keys were in the ignition. There was no drug paraphernalia in the vehicle. And an officer testified that based on his experience and training, the lack of drug paraphernalia suggested strongly that the person had become impaired elsewhere and then drove to that location. And so based on my reading of this court's opinion in Anderson, I think it could be that in that scenario, the lack of drug paraphernalia could be an inference that the impairment happened prior to the movement and allow.
But it seems to me that what was pivotal in Anderson was a favorable credibility determination by the trial court as to the facts surrounding, and I think it was specifically that there was a third person who drove the vehicle to the recreation facility. And there was a favorable credibility determination by the trial court. So in other words, the movement was explained to have occurred at the hands of a third person, and the trial court took the testimony of the accused and said, I believe you. See, so at that point, there's no inference, there's no nothing. The trial court totally accepted that it was this third person.
I think this court, though, addressed that argument in a slightly different way on appeal. In fact, the dissent in Anderson took that a step farther and said that the trial court could have discredited the defendant's self-serving testimony that he didn't drive to that location. And while this court acknowledged...
That's the dissent. You said it was the dissent, right?
I'm saying that the dissent made that argument, but this court rejected that argument to say that even though the trial court could discredit that testimony, in fact, it said, you can quote, even so, the state is still left with no evidence that the defendant had operated the vehicle after he had ingested the drugs, end quote. And so I think the issue that the court in Anderson was getting at is when you have evidence of impairment, you have to show that the operation occurred after that. And the state is in the same position in this case, in that the only evidence of impairment that the state has brought forth is the police officer. Of course, Mr. Wright stipulated that he was impaired, But then the police officer's testimony that he found Mr. Wright passed out with the drug paraphernalia still in his hand. There was no inference, even like in Anderson, where a trier of fact could have inferred that the impairment occurred elsewhere because there was no drug paraphernalia. In our case, in this case, there isn't even that inference because the drug paraphernalia was still in his hand when police officers found him. And so I think, Judge Mallory was certainly free to discredit Mr. Wright's testimony, but discredited testimony is not evidence. And the state simply has not offered anything affirmative in their case to say that Mr. Wright was impaired before driving to the vehicle. Now, I would note that in the state's brief, they offer two things, I think, to try to satisfy this burden. The first is the toxicology report on page 6 of the state's brief. And they point out the toxicology report shows a number of different drugs. The difficulty here for the state's position is that the toxicology report says nothing whatsoever about when Mr. Wright was impaired. And if the state actually believed that the toxicology report did in fact provide evidence that Mr. Wright was impaired beforehand, it could have, and presumably would have, had its toxicologist testify and explain to Judge Mallory that the levels were sufficient to show impairment before this time. Curiously, the state didn't do that. And so the toxicology report just doesn't have any probative value as to when Mr. Wright was impaired. The second thing that they point to is that they say on page 6.
So is it about the when or is it about the impairment? Because the when seems to be kind of, I guess there's an argument that it's understood that the ingestion would have taken place before the arrest. It wouldn't have taken place after the arrest. And thus that some of that, and because there's a crack pipe, right? So I think your argument would be like, oh, he was there and he, the crack was being consumed. I don't know if consumed is the right term, but at that moment after arrival, right?
Correct.
But there's other compounds that are found beyond the crack pipe,
Correct.
which would have been consumed, ingested prior to arrest. So putting those two pieces together, I think that there's a strong inference there that works against your client.
I would respectfully disagree with that, Your Honor,
Okay.
because I don't recall the number of compounds. There's no suggestion as to how high those levels were, whether any of those levels would rise to anything close to
So that's what I'm saying.
impairment.
Is it about timing or is it about impairment?
I suppose the answer is both, but ultimately, I think the key question is it has to be the timing of impairment coinciding with operation. And so it could be that 2 weeks ago, 2 weeks prior to this incident, that Mr. Wright smoked marijuana and there was still some of that in his system, but I don't think any toxicologist would testify that that residual level, although still present, in fact, many of the compounds listed, the values were just listed as present. So there wasn't even anything to indicate the amount or give a suggestion that he was impaired beforehand.
This was an A1A charge, right?
Correct.
And so impairment is a part of the charge.
Correct.
So we're not looking at the state proving this through some statutory level of a particular compound.
As I understand impairment, Your Honor, it would actually fall to the judicial level. I don't believe, and my friend can correct me if I'm wrong, I don't believe there's a statutory level per se or definition. I think it goes to the to the judicial level of under the influence, which this court has said it's just sufficient to prove that he had consumed enough drugs that adversely and appreciably impair his actions or mental processes and deprive him of that clearness of intellect and control of himself, which he otherwise would have had.
And the parties stipulated that that statutory element was satisfied, right?
Correct. Correct.
So in some sense, this lab report was unnecessary?
I think the lab report was unnecessary to prove impairment, but if the state wants to use it to suggest that he was impaired before this incident, to say that the levels present in the lab report show prior impairment, then it's critical. But of course, the state didn't offer a toxicologist to interpret it or to otherwise elaborate it. So
Didn't the parties explain to the trial court that the only purpose of the trial was to resolve the dispute as to whether movement existed?
that is correct, Your Honor. In fact, if I could just read this one sentence to that point, the court, Mr. Wright's counsel said, quote, "And the only issue is whether or not there was sufficient operation to sustain a conviction for OVI," end quote. And then the court responded and said, "All right, fair enough." Then turned to the state and asked, "Is that your understanding of the stipulation then?" To which the state responded, "It is, Judge, I accept it." And I think that stipulation clearly sets up the framework by which this court should also look at this issue on appeal. Impairment was accepted. The only issue was there movement after Mr. Wright became impaired? I think the state believed that they would be able to show some movement of the vehicle. Mr. Wright believed that he could show it did not, and he came to trial prepared with his video evidence and testimony to show that the vehicle could not and did not move because of the parking brake system. And fortunately for Mr. Wright, the state's own witness, the officer, confirmed his version of events, confirmed there was no movement. And at that point, there simply was nothing in the record to sustain a conviction.
Do we know if the court viewed the evidence regarding these interesting mechanical features of the vehicle, whether the court gave that a favorable credibility determination?
I'm not sure the answer to that. My reading of the transcript is that, I'm admittedly reading some between the lines. I think that the court ultimately decided that Mr. Wright must have been impaired before arriving at the gas station. That's my reading of the transcript. But the problem with that is that the state just didn't put evidence in the record showing that. And so while Judge Mallory.
But the trial court also could have determined that because the vehicle was in drive, that there could have been some driving that could have taken place. In other words, it seems like you're really relying on that evidence, that testimony, or that information about these special I'm going to call them special mechanical features of the vehicle, and yet we don't know if the trial court gave that a favorable credibility determination. And if the court gave it a disfavorable credibility determination, then all of a sudden the fact that the vehicle is in drive becomes far more germane to the operation and whether there was whether there was potential movement and so on.
That might.
While under,
Right.
while impaired.
I could imagine a scenario where that would be the case, but I don't think this case is one of them for a couple reasons. One, they showed the police officer's video body cam coming up to the vehicle. It's sitting there idle. The police officer confirms that there was no movement. I don't know what the court could even point to in the record to make an inference of movement. There's got to be something, right? And
Well, the vehicle's in drive, he's in the vehicle. I don't know whether, and perhaps there was no testimony about whether his foot was on the brake or not on the brake.
I believe he testified, and my memory is a little vague on this, I believe he testified his foot was on the brake. But the more pertinent testimony and all the evidence is that, number one, the emergency brake automatically engages, doesn't allow for movement. And then number two.
But again, that goes back to the you're assuming that it was a favorable credibility determination. Seems to me that your argument is premised on that this testimony, while there was nothing else but the testimony, that the trial court gave that a favorable credibility determination, absent a mechanic, absent anything else besides the testimony. And maybe I'm misunderstanding the record, and, certainly feel free to clarify.
I do respectfully disagree for the one reason that the state didn't offer anything to suggest that there was actual movement. I don't think the trial court is free to discredit testimony that the vehicle didn't move and then decide that, well, then maybe there was evidence of movement when there's nothing positive in the record saying that there was movement. I think the state has got to have something that shows, yes, there was movement. I mean, suppose Judge Mallory decided, well, the vehicle was running, and maybe that's evidence that the vehicle had moved. I don't think he can do that. I think the state has
Well, it
got to
seems to
offer
me
something.
if the foot's on the brake and the car is in drive, the vehicle's in drive, that makes it a very interesting inquiry.
Okay. I understand your Honor's question. I would just ask the court to keep or to enforce a tight rule on requiring the state to affirmatively produce all evidence for every element.
Let me just ask one more question. So if a vehicle is capable of being moved just by touching the gas, like if his vehicle was capable of being moved despite the fact that the emergency brake was engaged, does that make a difference?
I don't think so. The state still has to show some evidence of movement. Otherwise, it's speculative, right? The judge would have to say, well, if it's capable, I don't believe him, so I'm going to assume that there was, and I
Are
don't
you
think
saying
that
that it has
rises
to
to
be
the level
direct evidence? Is that what you're saying?
of movement.
Yeah.
Yes.
So you're saying circumstantial evidence would not suffice?
With apologies. If the vehicle was here 2 minutes ago, and I guess that would be direct, I can imagine a scenario where there'd be an inference or maybe an insinuation by something that was said that would show movement. Maybe he switched gas pumps or something that would be evidence of it. But there's got to be something affirmative.
Well, certainly we can infer on this record that he drove the car to the gas station.
100%.
And that's movement from wherever. I believe there's testimony that he came from some family event or something
Correct.
earlier in the day.
Right, his
And
parents'
so we can infer that he drove the car from the family event to the gas station, and that constituted movement. On this record, we can make that inference. Now, whether that movement coincides with the impairment is another question. But certainly, we can make that inference that that he caused movement of the vehicle at an earlier time in the day.
Correct. I don't think, I mean, that was his testimony as well, so I don't think there would be any dispute on that point.
And going back to how you initially phrased the issue, the question is whether the impairment that was stipulated coincides with any form of movement
Correct.
on this record.
It is correct.
All right, you've concluded your time. Thank you.
Thank you.
Morning, Your Honors.
Good morning.
Just briefly, a couple of things about the toxicology report. The only reason I put that fact in there was to discuss, as I think Judge Zayas got to, was the issue of impairment, obviously, because defendant on appeal had raised some question about whether he was impaired. I just wanted to make the greater point that given what was in the toxicology report, his demeanor, or I guess disposition when the officers arrived on scene, he was passed out, he was a little groggy and disoriented, that sort of thing, his acknowledgement to using drugs, that he was in fact impaired, just to cut that off. It had nothing to do with the timing of the usage of drugs.
And that element was stipulated.
Correct, and I think it was unequivocally satisfied. I would also suggest...
And was there any stipulation as to the timing of when the impairment began?
I don't think they stipulated to that fact. I think they stipulated to the fact that he was at the gas station, but I don't recall a stipulation to the notion that he actually ingested the drugs at the gas station. That is not my recollection of the record. So I think the lens that I looked at this case through was perhaps a little bit different than Mr. Truitt's. I don't think that there's a bright line rule or anything of the sort that's established in Anderson. These cases are invariably, fact specific. There was some reference to the Morgan case as well in Mr. Truitt's brief and my brief. And the evidence is often circumstantial. So,
Do we need evidence of movement at the gas station itself, or is it sufficient to take the inference that he moved the car from his family event earlier in the day to the gas station, given that we don't know when the impairment began?
I would agree with the latter proposition that, I mean, obviously, you know, this case is definitely distinguishable from Anderson. So I think as Judge Zayas pointed out in, or maybe it was you, Judge Kinsley, in Anderson, there was a credibility determination relative to who had actually been driving that vehicle, and there was some discussion of a third party.
Maybe I misread Anderson, but that's what I
Right, there was,
remember
there was
reading.
discussion of a third-party driver, but more importantly, in Anderson, there was
So was,
no.
is my recollection of Anderson the same as yours, that the trial court made a favorable credibility determination on the testimony of the accused that the vehicle had been,
I think perhaps it might have been
moved
this, might have been
by a
this
third
court because he was
person.
actually convicted in that case. That wouldn't be consistent with the,
so then that, then
that would have been this court.
so, okay.
But more importantly, there was basically no evidence of anything, you know, contemporaneous in either direction, whether before or after operation of the vehicle. You know,
Okay.
while the keys were in the ignition in Anderson, the car was turned off, the engine was not running, the driver's side door was open, the vehicle was unequivocally in park. And here, by contrast, you're encountering a vehicle that's in drive, the engine is running, the keys are in the ignition. It's a completely different scenario than what this court was confronted with in Anderson.
Was
So-
there any video introduced from the gas station itself
There was
that
some-
showed,
I'm sorry.
what happened? I mean, I'm assuming there was video that showed the defendant pulling in, parking the car, and getting gas. Was there any video introduced that showed what happened after that?
I don't recall there being any surveillance video introduced, period. What I recall was some body-worn camera from one of the officers.
Correct.
And that video was pretty ambiguous. You know, what I was looking for was, you know, was really looking to see if the gas pump was in the car, if things like that had happened, but it really only kind of showed what happened after the fact.
Correct.
It seems to me that this case might turn on this. So we have, we have evidence of movement of the vehicle, right?
Sure.
We have a stipulation of impairment, right?
Correct.
So it all comes down to whether there was movement after the impairment.
Correct.
Okay? And you have testimony, right? So is it enough for there to be that the trial court just didn't believe the testimony?
I think that would be the case, Your Honor. When you unequivocally have.
In other words, for there to be, they watched the demeanor and they said, I don't believe him.
Right.
And that's just,
Well, so I think Judge Mallory actually characterized defendant's testimony on the issue of the braking system as self-serving. But I think the greater point.
How does that weigh into sufficiency? Because isn't it the state's burden to present proof of the element of movement and that it coincides with the impairment? So how would the defendant's testimony play into that analysis?
So I think my greater point would be that this is obviously a circumstantial case, right? As these cases obviously typically are. You don't get the typical OVI where the officer sees the individual driving down the road, throwing beer bottles out of the window, swigging a bottle of vodka and yelling, "Officer, I'm drunk," right? So it's a circumstantial situation.
see, this is what makes it very interesting, is the combination of those two things.
Right.
Because for sufficiency, you take it in the light most favorable, right?
Right.
So because it can be looked at upon different ways, so then somehow, for manifest weight, then you're left with, is it enough for the trial fact to say, I just don't believe?
Right, and I certainly don't want this court to engage in inference stacking, but I believe the defendant had some credibility issues, starting with the fact that he initially denied using drugs, period, when that was clearly what had happened.
Well, what did the state present? What was the state's evidence as to movement?
I mean, unlike in Anderson, where you have a guy who is in a parking lot, car parked, key is in the ignition, but the car is parked, it's not in drive, the door is open, and the guy's passed out in the car. Here, the only logical way that car ever made it to that gas station was because the defendant drove it there.
Okay, so we have evidence that he moved the car from somewhere else to the gas station. Anything else?
The only evidence on the point of the timing of the drug usage was the defendant's own, attestation that he had only pulled out his crack pipe, as Judge Zayas referred to it as, and consumed the drugs after he'd arrived at the gas station.
And that was a statement he made when he was arrested and brought to the
That was
police
his
station?
testimony, and I believe maybe after the fact as well. And I think given the trial court's reluctance to credit what defendant had to say on the issue, and given some pretty demonstrable issues with credibility, the trial court could have discounted that and found, especially under the circumstances, that it's 4 in the morning.
Well,
he's
I want to go
driving-
back, though, to what
Sure.
the state is presenting.
Sure.
So the officer, I believe, as I recall, described how he found the car.
Sure.
And can you tell me more about that?
The ignition was running, the car was in drive, and the guy, Mr. Wright, was passed out behind the wheel.
But I believe the officer also said the car wasn't moving anywhere, like it was stationary.
Correct.
And he didn't witness it move any.
It got to the gas station somewhere, is what I'm saying.
So
And-
you're saying that it is the state's position that Mr. Wright was impaired before he parked the vehicle?
I think that's a pretty fair inference based on the facts and evidence. The fact that he is passed out at the wheel of a vehicle that is.
But he had a
not-
crack pipe in his hand. Does that make a difference, the fact that he had the crack pipe in his hand?
Any number of things could have been the case. He could have smoked drugs before, during, and after driving to the gas station. I mean, basically, I believe what a not guilty finding would hinge on in this case is a trial court crediting Mr. Wright's testimony. And it's pretty clear from the record that the trial court did not find Mr. Wright credible. So
I'm still struggling a little bit. Can you just, looking at this under a sufficiency lens?
Sure.
Can you tell me exactly what it is that the state introduced to show that he was impaired at a time when the car was moving?
no direct evidence. It's a circumstantial.
I understand that.
And I pretty much laid it out what, had I been the one making the case in the trial court, what I would have said, certainly, is that he had, he was obviously impaired. There's no disputing
Right.
that. The car had only gotten to the gas station because he had driven it there. The car is still in drive. I would just make the case that his testimony is not credible, and there's sufficient evidence, circumstantial, albeit, that he operated that vehicle before he arrived at the gas station.
Okay, thank you.
Thank you.
I would just ask this court to consider the rule that would come out of affirming Mr. Wright's conviction. If this court affirms, I believe that would change the plus side of the ledger of the bright line rule that this court articulated in Anderson, and that is a patron drives to a bar, becomes impaired, tries to sleep it off in their vehicle. Under the state's theory of the case, a judge can discredit that testimony.
This is different because his foot is on the brake and the car is in drive. Person that's sleeping it off on the vehicle has the car turned off.
But, Your Honor, suppose that we apply the same facts, that the person sleeping it off does the exact same thing. Under the state's theory of the case, the judge could discredit that person's testimony.
But that's the whole thing, is that we don't know whether this person's sleeping it off because of the circumstantial evidence, and we have to look at the evidence in the light most favorable to the state. So it seems to me that you're asking us not to look at the evidence in the light most favorable to the state.
I think it's a little different, Your Honor. I think what I'm asking this court to do is to say that unless, if a vehicle is found off the road and stopped, that unless there is something that creates an inference of concurrent operation with impairment, a court must dismiss. The court noted this point in Anderson by saying, what was the inference there? The inference there was that there was no drug paraphernalia. And I think the lack of drug paraphernalia could be enough of an inference to say you must have taken it somewhere else and then driven here. But here, of course, we don't have that. Officers found Mr. Wright with the drug paraphernalia. And I think if we affirm, then all of the sleeping it off cases, a court really could just discredit that evidence and say, how do we know that you weren't impaired when you drove to the bar? And if the court discredited that testimony, now
I think you're taking it too far, because the sleeping it off, that's the problem we have here, is the trial court could have determined that your client was sleeping it off or not, depending on the facts. And the trial court went a certain way.
I understand your Honor's position. I would just point out that
I think that there are some issues here, but I don't know that that's the issue.
Again, I would just say that I think the state has failed to identify any single piece of evidence, direct or circumstantial, that a fact finder could say, yes, Mr. Wright was impaired before.
So what it comes down to, I think, is the question I have, and it's, if I tell you the source of the question, it's a little funny, and it's Judge Myers. I have Judge Myers ringing in my head for the last 10 minutes or 15 minutes or whatever, 30 minutes that we've been doing these arguments of why is it that, you know, if the court didn't believe the defendant's testimony, why isn't that enough?
And I believe it's because you can't prove a negative, meaning that it's the state's burden to offer something. And then at that point, once the state has offered something, then disbelieving the defendant can happen all day long, but
That's
the
thing.
reverse can't be
Let me,
true.
let me ask it differently. You have circumstantial evidence that can go either way, which you have here, okay? And then you have the testimony of the accused, and I have Judge Myers ringing in my head. And this is like, oh, I'm saying it like verbatim, like, can't we, you know, because there, it isn't like the trial court has spoken and said, I find him credible. And so, in presuming the regularities, doesn't this reflect that the trial court didn't find him credible, and then isn't that enough, given putting that together with the circumstantial evidence?
I think then where,
It's a difficult question. I mean, it really isn't, I think that that's really the key here.
understand, I think then where my viewpoint would differ from your honors is that I don't believe that there
I have
is.
a viewpoint, I have questions.
Understand. Maybe differ with your question then, is that I don't believe there is circumstantial evidence. And I think that is the premise of your honor's question, because a person could say, a patron coming out of a bar that's impaired, isn't that circumstantial evidence that maybe they're a drunkard and came to the bar impaired? How far do we take inferences of circumstantial evidence? And I just don't think that a court or a fact finder can take any inference on its own without something positive to say, some affirmative evidence to show, yes, that person drove to the bar impaired. Yes, Mr. Wright drove to the gas station impaired. There's got to be something. I don't think disbelieving the patron or disbelieving Mr. Wright is enough to create that.
I mean, you're calling it, but it seems like you're looking for direct evidence, and I think it's very hard. I don't know, but it seems to me that seems to be part of the pivotal determination in this case.
Understand.
And again, Judge Myers, if she watches this, she's going to laugh, and she'll probably remember, because I mean, I'm remembering this like it was yesterday. Thank you.
Thank you.
Thank you. We'll take the matter under submission and issue a timely written decision. Enjoy the rest of your afternoon. Mr. Hill, you are staying with us, correct?
Correct.
All right. The final case to be argued this morning is C-240151, State of Ohio versus Michael Thomas.
Good morning, Your Honors. I'm struggling with a bit of a cough, so I'm just gonna try to get this out of my system real quick.
Okay.
course.
Do you want to step out real quick? Do you need, if you want to step out, that's fine.
Oh, I'm okay. I just
Okay.
want to make sure I clear my throat first.
You're welcome to take your water up with you if you'd like.
I might have to come grab it. I'll probably knock it over if I bring it up here, so I'll just leave it there.
Would you like to reserve time?
Yes, 3 minutes, Your Honor, please. Thank you, Your Honors. Good morning. On behalf of Michael Thomas, this case centers around an exculpatory NIBIN report that wasn't disclosed until after the defense had finished its closing argument. So really as close as it could have come to being after trial, but still during trial. And this NIBIN report
The
contained...
state raises the argument that this doesn't trigger Brady because it was technically during the trial. Do you agree with that?
I do not agree. Now, it's important to look at what exactly this report contained, because there were different categories of evidence. And the most crucial exculpatory evidence was evidence of the fact that these bullet casings, these 5 bullet casings, which all matched one another from this shooting, matched the bullet casings from a March 2022 shooting. So this was evidence that the state actually had 8 months prior to Mr. Thomas even being arrested for this case, let alone having his trial. So it's very important to separate that piece of evidence in the report from the evidence
Well,
that...
do we know that it recognized the match, or was it just sitting on the information that could have created the match?
Well, according to the officer's own testimony, every time there's a shooting, the casings are collected and they're sent to the Crime Gun Intelligence Center, and they're processed within 24 to 48 hours. And within that time frame, that processing inherently includes running it against all other bullets in the system, bullet casings in the system to see if there is a match. So taking that to say the March 2022 bullet casings would have been collected at that time, because they say they, like I said, they collect all bullet casings and send them to the CGIC. Within 24 to 48 hours, those March 2022 bullet casings would have been in the system.
That describes what's typical or what normally happens. Nobody testified in this case that that did in fact occur on that timeline, right?
I guess specifically, no. There was testimony, as general testimony, that they do this process in every case. So if you, on one hand, if you take them at their word, yes, this was done, this happened in March 2022, and then when these were collected in November of 2022, that also occurred, and the comparison would have happened at that time. So generally, if you take them on their word that this happens in every case, yes. Specifically, no, we don't have that. But that does not that does not save the state from a Brady violation, because there's plenty of cases in the Brady and its progeny, Strickler v. Green, for example, that says the state has a responsibility to obtain this exculpatory evidence. If for some reason they were sitting on this evidence, or they were negligent, and for some reason this 0.1% of the circumstance didn't occur in this case, they didn't do it for some reason because somebody forgot or whatnot, that does not exclude the state from their obligations under Brady and its
Am I
progeny.
misunderstanding the record? Was there testimony that the processing was done, but the March incident was not found at that time?
Yeah, there was specific testimony that these casings from this shooting, November 2022, were run through the system, and the officer testified that they did not hit any matches. So he either didn't check his report, didn't check the evidence, didn't go back into the system and pull what he was supposed to pull. So that's one possibility. Another possibility is, for whatever reason, they hadn't run those March 2022 bullets. I have to say that doesn't really make sense, because then when the arrest occurred that produced the gun, the August 14th arrest that occurred that brought this all to light, that March 2022 evidence was in this report. So it makes no sense that that running wouldn't have occurred back in March 2022, and then all of a sudden it did occur at this time during this trial.
Does the disclosure during the trial, though, take this outside of Brady and put it in Rule 16?
I don't believe it does, at least for the evidence of the March 2022 of evidence, because that clearly was available prior to trial. All of this was, honestly. The trial, it was bad timing. The trial started August 16th. This report was created August 17th. The state disclosed all of this on August 21st. So the August evidence was available as of August 17th, which would have been helpful to have it actually disclosed on that day instead of 4 days later. Every day would have helped. But as to that March 2022 evidence, it clearly was available ahead of time, and the fact that it was still presented technically during the trial, I don't think pulls it into Rule 16 instead of Brady, because you have to look at the prejudice suffered by the defense as a result, and it's exactly the due process prejudice that Brady covers, and that is because the fact that this was not turned over, the defense really was forced into the position of really choosing a much weaker theory of the case, which was to essentially disavow evidence that a shooting even occurred. The defense's theory literally was that this shooting was fabricated by the defendants.
Well, I mean, the opening statement, I believe,
I meant victims, not defendants, sorry.
I understand that. I believe in the opening statement, the defendant's attorney did argue, we doubt that this even happened. Alternatively, it wasn't him that did it. There was no evidence that he did this shooting, if it did take
Right,
place.
if it did.
So it was an alternate. So it's not like the defendant solely relied on theory A rather than theory B, correct?
That's true, but there's an important clarification to that. Two clarifications. First, it was very much largely the theory that this was a fabricated incident. But as to the alternate theory that someone else did it if the shooting did happen, there was no one to specifically tie this to. There was no specific alternate suspect that could be credibly linked.
Wasn't that the purpose, though, of I believe it was a 3 or 4 month continuance?
Well, there was a lengthy continuance, and we do argue that trial counsel should not have basically laid down and said that continuance was good enough. The trial counsel started off with a motion for mistrial. There was discussion of, well, we'll give you a really lengthy continuance, you can do further investigation, you can reopen the evidence, whatever you want, and go for it. And trial counsel said basically, okay, we submit, and I'll get into that if I have time, as to why that was a failure on trial counsel's part. They should not have agreed to that.
But as far as whether, talking about the Brady assignment of error,
Yeah.
regarding whether there was a prejudicial Brady issue, did the fact that there was such a lengthy continuance, does that cut against prejudice?
I don't believe so, and the reason being, basically essentially the entire trial had occurred by the time this evidence was turned over, and this was a bench trial, but you look at what the defense had presented to that point and the arguments that had been made, and especially look at the closing argument that had been made right before this evidence was turned over. And despite that trial counsel in the opening gave that sliver of, if this did happen, it was somebody else, it was very much largely the defense theory that this was a fabricated incident altogether. And so you really have the defense going through with every witness presented, because the defense did not present its own case. It was all based on cross-examination and drawing out evidence from the state's witnesses that this was a fabricated incident, and then really hammering that point home in the closing argument. And so then to even say, have a really lengthy continuance and present whatever evidence you want, well, they would have to completely contradict everything that they had just said. And so you lose so much credibility at that point. Now, you can look at it and say, like, well, this is a bench trial. The judge can sort that out. We'd submit no, that it had just gone too far. They had really put all their eggs in this basket based on the state's failure to disclose this. This was evidence the state either had or definitely should have had and was not turned over to the defense. The defense could have had solid evidence to actually present who an alternate suspect could have been, but they did not have that evidence because of the state's failure. And so the defense had to go with this much weaker theory than presenting what they would have liked to. This was somebody else that did it, and here's who it could have been, and here's why. And the who very likely could have been.
Why did the continuance not provide that opportunity?
We would argue that the theory at that point is so contradictory. It's so contradictory. It's completely contradictory to present a whole case based on disavowing the evidence, essentially, and saying, look, you planted these casings, because this is what the defense argued. The defense argued the casings were planted in a small cluster together, which was not realistic. No one saw the actual damage to the car until 8 months later. The victims claimed certain damage occurred, such as the tires being shot out and the car wasn't drivable, and it turns out that wasn't the case at all. That
But
it-
didn't the defense come back and cross-examine the officer on the newly disclosed report and present evidence from it so that the trial court was aware of it when it issued its finding?
Yes, but the important point is, the defense was not in a position where they could really present this as their leading theory. It really was kind of like, well, we've really painted this strong picture as to why this shooting didn't even occur. And now, because of the state's wrongdoing, we have to sheepishly come back and say, oh, there's this other evidence, and, you know.
Couldn't, I mean, are you saying that it couldn't have been alternate theories?
I'm not saying there couldn't be. I'm saying if you go through and read how vigorously the defense relied on this theory that it was all fabricated, compared to having to switch it all up based on the wrong position that they were put in by the state, I submit a lot of credibility would have been lost. But I also, a very important point to add to that is trial counsel, I think everybody was so taken aback that this happened. I don't think anybody was really looking at it through a clear lens. But another failure of trial counsel is, and no one picked up on this, because of the March 2022 evidence that was in this report, that again, should have been known prior to trial, long prior to trial, that shooting occurred on Hale Avenue. There was testimony in this trial that Renice Crawford's nephew used this maroon car on the night of the shooting and went to the Virginia Apartments on Rockdale Avenue, which is in short walking distance of Hale Avenue. So no one, trial counsel, the court didn't notice, no one brought out the fact that the best exculpatory evidence in this report that wasn't turned over is that there not only were other alternate suspects named in the report, the people that had the gun and the people arrested with, but somebody whose name could have been known, Renice Crawford's nephew, somebody who there was evidence that he had the car that night and that he went to this apartment that was within walking distance of where these bullet casings were found of the March 2022 shooting. This is exactly, we've all heard of wrongful convictions. This is exactly how the doors are open to those situations. You have, a defendant saying, I didn't do this, somebody else did it. There's no clear evidence. Well, we want to know who an alternate suspect is. That was the position the defense was in here, saying somebody else did it. They didn't really have anyone to credibly point to until they get this report. And then, now again, trial counsel failed in not drawing out this aspect, but there is evidence that these bullet casings matched bullet casings from a shooting that was in the exact walking distance of where somebody using that car that night was, that very night. And that's crucial.
And
Now-
counsel, you're out of time.
Oh, thank you, Your Honor.
Thank you.
Again? Want to briefly reiterate, as I laid out in my brief, why this is not a Brady violation. The law in Brady is pretty cut and dry. It applies only to post-trial disclosures of evidence that was known to the state and not known to the defense. And here, setting aside the issue of whether the state even knew about it, and there was testimony to the effect that the investigating law enforcement agency, Detective Zopfi, CPD, had no idea about this match until trial. The fact of the matter is disclosure came
Well, does
during
that
trial.
really matter? I mean, aren't these testing agencies part of the state too, and don't they have an obligation to turn over the information?
I think NIBIN is a national, right, National Ballistic something. I don't really know what the acronym stands for, but I think it's a national database. So, defense counsel raised an interesting point relative to how this, lack of a identified match could have happened. And it could be the case that maybe those March 2022 shell casings weren't entered into the database until after Detective Zopfi went and tried to do a NIBIN, which would probably implicate a Brady violation in that other case to the extent that they could identify who shot those bullets off in March of 2022.
In essence, what you're saying is it doesn't matter regardless, because it's not a Brady violation, because there was disclosure before.
The end of the trial.
The end of the
Correct.
trial.
I mean, it's pretty cut and dry. The law on that is pretty cut and dry. I think this is more accurately, viewed, to the extent that it's viewed as any kind of a violation at all, as a Crim Rule 16 violation.
And so that would be the source that we would look to for how to remedy this, let's just call it a late disclosure.
To the extent that the court is inclined to believe that there was any violation at all. I mean, we're not conceding that there was even a discovery violation. The testimony was to the effect that this report showing this match was generated on August 17th. Detective Zopti became aware of it on the 21st. He immediately disclosed it to the state. The state immediately disclosed it to the court and the defense. So there was really no, certainly willful feet dragging, and that, I believe, gets to the first element of what, a court should do in terms of remedies here. I think a mistrial was not the appropriate remedy. There was no abuse of discretion in denying a mistrial under the circumstances at issue here.
One of the claims that's been raised is about waiver of right to a jury trial, and that the defendant would not have given up his right to a jury trial had he known about this information. Can you address that?
I think a lot of that is really speculative, and it all hinges on what you believe and what defense believes the the merits of whatever potentially exculpatory evidence they could find is. And I think is this 4-month continuance where they had the opportunity to go through everything and try and track down leads and find out what the significance of this match was. There wasn't a whole lot to it. I think there's just a complete failure to demonstrate any real prejudice in this case by virtue of what happened with this disclosure. I think it's a little bit, there's a whole lot of would have, should have, could have going on here, and I don't think that rises to the level of prejudice that needs to be established.
So
that's-
go ahead.
Unfortunately, that's the nature of this, is that, we've got this prejudice prong, and the defendant is very difficult to really survive that hurdle. In this case, appellate counsel has raised the ineffective assistance of counsel.
Right.
And within there were two things that I'd like for you to address. One is the failure to really kind of hone in using the evidence with this alternate suspect. And the second is the failure to request a mistrial.
Well, so defense counsel did declare a mistrial in the first instance, right? And the trial court did leave the door open for them to ask for a mistrial at a later time, right?
Mm-hmm.
So what you had here was you had this 4-month continuance where defense counsel was afforded the opportunity to investigate all these leads, determine what the significance was. And apparently, at the end of the day, they weren't really able to find a heck of a lot. And so does that really how does that change the calculus based on the standard for a mistrial, which is you have to find a willful violation, which there wasn't. You have to find that, that there was prejudice from not declaring a mistrial, and in the context of a situation where this potentially exculpatory evidence doesn't really show a heck of a lot, how can you say that there's prejudice?
Well, I think, it seems to me that part of the argument is that, defense counsel is presenting the case as best as they can based on what they have as
Sure.
knowledge. And now the realm of knowledge all of a sudden changes, and the concern that any pivots by the defense counsel would so undermine credibility that they wouldn't be able, that they wouldn't be able to effectively use this evidence.
I don't think that's the case. First of all, I think as Judge Bach pointed out, this was a situation where the defense theories were not potentially mutually exclusive, and in fact, there was some insinuation that to the extent that somebody did in fact shoot Miss Wood's car, that it was not defendant. So this proposed third-party defense, to the extent that there was really any evidence of it, which there wasn't, would not potentially be inconsistent with this idea of fabrication. The bigger issue, I've lost my train of thought here in the midst of this. The bigger issue is that this was a bench trial. This is not a jury. This is a sophisticated, arbiter, Judge Wagner, who gets it, who understands the situation. A jury, probably wouldn't be able to wrap their head around shifting gears at the last minute based on this late disclosure of evidence. And, also just given the delay in the proceedings, it wouldn't have been feasible to do a jury. So if this were a jury trial, for instance, a mistrial would have been warranted. But under the circumstances where you're talking about a bench trial with a former prosecutor and/or defense attorney judge who understands how all of this stuff works, I don't think you can show prejudice in that circumstance. So unless the court has any additional questions, I'll submit on that.
I wanted to hone in on one other thing about whether a Brady violation occurred or not. There is some case law saying that even disclosure of potentially exculpatory evidence during trial may be a due process violation if the late disclosure significantly impairs the fairness of the trial. So, considering that, and that's an Ohio Supreme Court case, considering that statement, could this still be a Brady violation?
I don't believe so, because I don't believe the defendant's defense was particularly prejudiced by the late disclosure of this information. I'm not buying this idea about a third party, the defense theories that could have, would have, should have been pursued that were not pursued. I think every indication is that defense counsel had a lengthy period of time to investigate all of this, and just the sad fact of defendant is that it didn't turn up a heck of a lot. So I don't think that there's been an affirmative showing of prejudice that would sustain a due process violation in this case.
Okay, so, never mind.
Thank you.
One quick point I want to make is, even if this court does not find a Brady violation, we'd argue that a mistrial still would have been the appropriate remedy, and that this continuance was not sufficient. But just going back to the prejudice suffered, I will just emphasize, start to finish, despite the remark that if a shooting occurred, it was somebody else, really the defense put all their eggs in this basket of this being a fabricated incident. And the state can come and say, this is a coulda, woulda, shoulda thing all day long. But the fact is, this report has specific evidence that links a specific alternate suspect to this evidence. There was evidence in this trial that Renice Crawford's evidence used this maroon car on the night in question. There was evidence that he was going to the Virginia apartment.
Brady standard requires us to look at whether there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. And Brady claims, in my experience, typically come up in a post-conviction or new trial posture where there's an opportunity to create a more robust record of what exactly the evidence was and how exactly that evidence would have undermined the outcome in the case. But here, we're not asking that question in a vacuum because we had the evidence be disclosed in the proceeding, and then we had this continuance, and we had the evidence be used in some way, and I understand that your perspective that the evidence was used ineffectively.
Correct.
So how do we adjust that prejudice standard or that definition in Brady? Because we're not dealing with hypotheticals, we're dealing with the reality. So is the question whether the evidence would have been disclosed sooner, and what would have happened if the evidence was disclosed sooner, and how do we know what would have happened because we're not dealing with a record that really answers those questions for us?
Yeah, that's a good question. I think initially the problem is, especially, again, there are different categories of evidence within this report, and I keep talking about the March 2022 casings. Let's just look at that again. If that had been turned over prior to trial, the defense could have cross-examined all of the state's witnesses as to that effect, and they could have presented their own evidence as to a specific alternate suspect. They could have pursued DNA testing.
Why couldn't the defense counsel have done that during that long continuance?
Well, there's a multifaceted answer to that. I think defense counsel should have done that. On the other hand, I don't think that even the 4-month continuance was sufficient to do that because, and I break this down in the brief, if you look at the steps that would actually have to occur to do DNA testing, of the casings and do comparative testing and really draw out the evidence that should be drawn out from these casings, it would take much longer than 4 months.
But that's not really in our record, right? I mean, isn't that a post-conviction-esque claim?
How long that would have taken? Yeah, I mean, there's no specific evidence as to how long it would take, but, you know, looking at the steps that are part of that process, you know, and looking at just the logistics of this case, there are witnesses who lived in the same building, the same apartment building as one another. There are witnesses in romantic relationships with one another. If you, and DNA testing wasn't pursued, but had it been pursued, an even lengthier continuance would have been required. And, you know, the Ohio Supreme Court and the U.S. Supreme Court have all recognized a speedy resolution is needed to criminal trials. You know, the anxiety and stress of pending charges, let alone a pending trial, there needs to be a speedy resolution for all parties involved, just for the justice of the situation. There's no specific evidence in this record as to what DNA testing results there may have been, but that just highlights one, trial counsel's shortcomings of what they should have pursued and what they didn't. And, you know, another misleading fact by the state, you had a state officer in this case testify that DNA testing of casings has never been fruitful. And well, there was a case here in Hamilton County less than a year ago where there was an exoneration based on DNA testing of bullet casings, the Marcus Sapp case in May of 2024. So there's precedent that the court can look at in this record of how DNA testing of casings can lead to exonerating results. And there's specific evidence in this case of how cross-comparing, you know, DNA testing on these casings with specific alternate suspects could have presented a much stronger theory of this case, which would have required a lengthier continuance, which, you know, reasonably should have just been a mistrial and starting the trial over, where all the investigation that should have been done could have been done in the proper way. The time that was needed could have been taken. There's evidence in this case that...
And counsel, you're out of time.
Okay,
I'd like to wrap up.
Okay, one final point. Another alternate suspect that Renice Crawford mentioned was Jeremy Adams. His picture was actually shown to witnesses at the scene. Now, it just goes to show another example of what could have happened had this evidence been turned over. Renice Crawford's nephew, his picture could have been shown by either investigators or defense investigators had that evidence been turned over. So there's a lot of different evidence that could have been developed if this evidence had just been timely turned over by the state as it should have been. Thank you.
We'll take the matter under submission and issue a timely written decision. Thank you for your arguments this morning. Enjoy the rest of your day. The court's in recess.
All right.